From celebrity lawsuits to viral controversies, this is Exhibit A-List, where pop culture gets cross-examined. I'm Jasmine Weg, and I'm your lawyer bestie breaking down the legal stories everyone's talking about. Okay, before we get into anything, I need one moment because the New York Knicks are going to the NBA Finals, and as a born and bred New York City girl, this is a big deal. The New York Knicks are one win away from their first appearance in the NBA Finals since 1999. So give it up for the New York Knicks, guys. So proud of them. All right, guys, welcome back to Exhibit A-List, where pop culture gets cross-examined. I'm Jasmine Weg. I'm your lawyer bestie here to bring you all the latest, greatest lawsuits that are just buzzing about and break them down for you in real human talk. Subscribe wherever you listen, rate, follow, review, do all the podcast listener good deeds that you can do. You'll feel so good about yourself after you do them, and guess what? I'll be so happy. Also, follow me on Instagram, JasmineWegESQ. Let's get into it. It's a big episode today. So first up, we're going to talk about whether you can sue a brand for calling your product toxic. Now, I feel like everyone has heard at this point that traditional nonstick pans are not considered healthy, and we've all been tasked with balancing what do we do when we want to make an omelet that doesn't stick to the pan, but we also we don't want to have to clean the stainless steel, but we also don't want toxic chemicals leaching into our foods. Now, when I was on a search for healthier cookware to move away from nonstick, I found Caraway pans. I bought myself one. It was a little bit of a splurge because it's expensive to me. And I heard about it on all my favorite health podcasts. Everyone was pushing them. And I don't know if I was being influenced, but I've been so happy with my frying pan that I bought so far. I use it all the time. It is getting a little it's not as pristine as it was when I first got it, but I'm super happy with it. And about a week ago, I got this email from Caraway saying that they're being sued by what they call big cookware. I found that very intriguing, and I had to dig in, find out what this lawsuit is about, and here we are. So on February 13th of this year, two of the biggest cookware conglomerates in the world filed a federal lawsuit against Caraway in the Southern District of New York. That's where I'm at, guys. This is in my backyard. The plaintiffs are Group Seb, they make All-Clad, T-File, and then Mayer Corporation, which makes Farberware, Rachel Ray, Analon, and Circulon. So these are the big names that we all know. When I got married, I got a set of Analon cookware. It's actually a dope set of cookware. That stuff is non-stick, it's heavy duty, and it's really good. But I was worried about the potential chemicals in nonstick. I still have it though. But from day to day, when I take out a frying pan to make eggs, I'm always taking out my Caraway. Maybe because I splurged on it, or maybe because it's healthier. I don't know, guys. But these two companies, they make up a massive portion of the cookware sold in America. So I get why Caraway is dubbing them big cookware. They're furious. The lawsuit alleges false advertising, commercial disparagement, trade libel, and unjust enrichment. So the core argument is that Caraway built its entire brand by falsely characterizing PTFE-coated cookware as toxic, cancer-causing, and full of dangerous forever chemicals, and that this characterization is chemically inaccurate and designed to scare consumers into switching brands. Now, first of all, I just want to say my gut feeling here. Every brand that is differentiating themselves by not using those chemicals is going to advertise with it. Come on. They're going to say, hey, we don't have PTFE on our coating. We're using ceramic. We are distinct. We're different. I was seeing that in bargain brand stores, like when I would go to Marshall's and check the frying pan aisle, there were plenty of frying pans, like Green Pan, for example, and many others that were advertising that they didn't contain these chemicals and that they were made of alternative substances. So you're going to fault a brand for trying to steer away from something that it believes to be unhealthy, and then for touting that because it's something it's proud of, that bothers me a little bit. But the plaintiffs, they're seeking an injunction. An injunction is when you want to stop something. It's not when you're trying to get money, as most lawsuits we hear about, but it's we want you to stop doing this thing that we don't like because it's causing harm. So what's their harm? They're saying that Caraway is making these claims about toxicity of their products, and they shouldn't be doing it because it's hurting them. It's hurting their sales. So the plaintiff's argument is that PTFE in modern cookware is PFOA free. Now, I know that's confusing because it's a lot of P's and F's, but PFOA is the specific compound that was identified as harmful and was phased out of cookware manufacturing by 2013. So today's PTFE, whatever is used to coat these nonsticks, according to the FDA, is safe for food contact. Now, we know that just because the FDA approves it doesn't mean that it's 100% safe. I mean, I'm talking about us in the discerning world, us who don't take everything told to us for granted. The FDA has authorized PTFE for use. The Consumer Product Safety Commission has rejected calls for warning labels on PTFE cookware. The plaintiffs argue PTFE is chemically inert, practically insoluble, and cannot even theoretically degrade below 500 degrees. And that's a temperature you cannot reach on a standard home stovetop. Now, Caraway's argument is that PTFE is still a PFAS chemical, a forever chemical. It is still part of the broader family of forever chemicals. Multiple states have passed legislation restricting PFAS in cookware. The EU has moved to regulate it. Minnesota banned it. Caraway says it's simply telling consumers the truth about what is in their competitors' products and offering a cleaner alternative. Now, my take is that, honestly, just because the FDA and everyone else hasn't caught up doesn't mean that Caraway is wrong. They could just be behind. But under the Lanham Act, federal false advertising statute, a plaintiff can sue if a competitor makes a false or misleading statement of fact about its own or someone else's products that causes commercial harm. So the keyword is fact. Statements of pure opinion are generally protected, but if you're making a specific factual claim that a product releases toxic fumes or causes cancer, then it needs to be scientifically substantiated. Caraway's defense is going to be that the statements it made were substantially true and that there is science backing their statements, and I'm sure they have the studies to back it, and that they were entitled to tell consumers what is in their competitors' products. So now we are going to see how the science holds up in court. And next, we're talking about Elon Musk and his $150 billion loss on a technicality. Elon Musk, one of the wealthiest people on the planet, with literally access to any attorney in the country, just lost a $150 billion lawsuit. Not because the jury found that he was wrong, but because they found that he waited too long to sue. There was 3 hours of deliberations, a unanimous verdict, and it was busted on statute of limitations. I find that crazy because how do you have the money to hire any attorney and end up bringing a lawsuit that's busted on statute of limitations, a threshold issue? Like, you have to know what the statute of limitation is going in. But the background of this case is this. Elon Musk, in 2015, with Sam Altman and Greg Brockman and others, co-founded OpenAI as a nonprofit. The explicit mission was to build artificial general intelligence that would benefit humanity rather than any single corporation. Musk says that he gave approximately $38 to $44 billion to get it off the ground based on those promises. By 2017, it became clear that building advanced AI required billions of dollars in computing power that charitable donations could never provide. Musk proposed a solution. He wanted to take control of OpenAI himself, either through a majority stake or by folding it directly into Tesla. Altman and the co-founders said no, so Musk quit the board in 2018 and stopped funding. In 2019, Altman created a capped profit subsidiary inside the nonprofit to attract outside investment. Microsoft actually poured $13 billion into OpenAI. The company stopped open sourcing its code and went from a scrappy nonprofit to a company now valued at $852 billion. So in 2023, Musk then launched xAI, a direct competitor. And in 2024, he filed this lawsuit. So he claims that Altman and Brockman committed fraud by using altruistic language to take his money while secretly planning a commercial pivot, and that OpenAI abandoned its public mission and became effectively a closed source subsidiary of Microsoft. Now, OpenAI's defense was that Musk always knew about the transition plans and was simply a bitter competitor trying to use the courts to sabotage a rival. Their lawyer called the lawsuit a deliberate act of sabotage by a hypocrite against a competitor. So a statute of limitations is a legal deadline. Every type of legal claim here in the US has one. After a certain number of years, you cannot bring the claim regardless of whether it had merit. And the purpose is to ensure that the defendants are not forced to defend themselves against stale claims years or decades after the events have occurred, when memories have faded and evidence has all but disappeared. California's statute of limitation for the types of claims that Musk brought is generally 3 years. The jury found that Musk knew about OpenAI's for-profit pivot and the departure from its nonprofit mission well before 2021. And he filed this lawsuit in 2024. He was too late and the clock had run out. The critical thing about this outcome is that the jury never reached the underlying question of whether OpenAI actually stole a charity. The court never ruled on whether the founding promises were made and broke. Those questions remain legally unanswered. Musk has vowed to appeal to the Ninth Circuit, and if the court takes the case, the substantive issues could finally get a hearing on the merits. Like I said before, the crazy thing is that Elon Musk has a team of some of the most expensive attorneys in the country on retainer at any given time. So I find it very hard to believe that nobody told him that there was a statute of limitations problem with this case. My theory is that his attorneys absolutely warned him, and he said to do it anyway. And they said okay because he's paying those bills. So this lawsuit may have been less about winning in court and more about the discovery process, about getting OpenAI's internal documents into the public record, and about creating a narrative around Altman and Microsoft that's now in the public and now we know, and also about slowing down OpenAI's IPO plans. All of that did get accomplished through the litigation, even if the case was dismissed. So you don't always sue to win. Sometimes you sue to disrupt. And our next story is kind of dark. Dalton Eatherly, a 28-year-old Tennessee-based live streamer who goes by the name of Chud the Builder online. I personally never heard of him until this case came out. He films himself in public, confrontations with strangers, primarily Black people and other minorities. According to what I've read, he uses racial slurs and makes provocative statements to them while live streaming. I actually can't believe that his content is allowed to be on platforms. But then again, TikTok allows tons of anti-Semitic content every single day, and every time I report it, they just let me know that they're sorry. So I'm sure this kind of content is making its rounds as well, even though it's disgusting. Anyway, on May 13th, Eatherly was at the Montgomery County Courthouse in Clarksville, Tennessee for a civil case involving credit card debt. While there, he got into a confrontation outside the courthouse with a man named Joshua Fox, a Black disabled veteran and a father of 3. According to the arrest warrant, he got into a physical altercation and then fired his weapon at Fox. Fox was struck multiple times and was flown by helicopter to a hospital. Eatherly was also shot, apparently by his own weapon, during the struggle and was taken to a hospital in stable condition. Now, this Chud guy was arrested and charged with attempted murder, aggravated assault, employing a firearm during a dangerous felony, and reckless endangerment with a deadly weapon. Now, it's almost as if his rage-baiting methodology has actually created rage in others, and that's what led to this altercation. And it seems like he's a pretty rageful person himself, whipping out a weapon and shooting a random person. Apparently, he also decided to live stream himself from the stretcher. Just days before this incident, he had been arrested at a Nashville bar after refusing to pay his bill when staff asked him to stop filming, and he was already on bond for a separate harassment case in Montgomery County from November. Now, attempted murder in Tennessee is a Class A felony. The judge at his arraignment specifically noted the attempted criminal homicide charges carried a possible sentence of 15 to 60 years in a state penitentiary. Now, his defense is self-defense, but if your entire documented public life is a series of deliberately created confrontations, that context is going to be very relevant to whether a jury finds your fear of imminent harm was reasonable. because that's what self-defense has to be. And then there's the victim. Joshua Fox, a disabled veteran, father of 3, that's a very sympathetic victim. The DA has already framed this as attempted murder, not a mutual altercation. The community response in Clarksville has been significant. Eatherly's prior pending harassment case plus the Nashville theft and disorderly conduct arrest are all going to factor into bail conditions. And the broader question that this case raises is one that the legal system has been grappling with for years. Is content that deliberately provokes confrontations protected speech? Now, generally, yes, First Amendment protects offensive speech, including racist speech, unfortunately, because yuck, in public spaces. But the First Amendment does not protect you from the consequences when the speech escalates into physical violence. So the moment that Eatherly reached for his gun, he left the realm of protected speech and entered the realm of criminal conduct. Now that live stream from the stretcher is going to be used in court. Okay, and now I saved the best for last because this one is just, it's like a love letter to every attorney who's ever watched their client do something, let's say, interesting on social media and have to sit with it quietly. So Mikayla Nogueira, for those of you who don't know her, she's one of the biggest TikTokers in the world. She has 17.4 million followers. She does makeup tutorials, and she's got this crazy Massachusetts Boston accent that people question the legitimacy of all the time because it's the most intense accent you've ever heard. She says, like, you know, when they say, I park the car in Harvard Yard. She's like 10 times that. She's like, I don't even know how to imitate it. I can't do it justice. Google her after you finish this podcast. Listen to her videos. You might find it endearing or they might drive you up the wall. But anyway, she filmed this Get Ready With Me for divorce court. And then she goes, we're serving see you next Tuesday, CUNT energy for this appearance. And how does she serve see you next Tuesday energy for the appearance? Well, she gets a brand new Birkin on her arm, a fresh out the box pair of Louboutins, and she ices herself out. She said she was channeling Kim Kardashian energy by putting on lots of diamonds on her wrists and fingers. Now, I want to remind you, Kim Kardashian iced herself out for a court appearance, but it was when she was appearing in France for that court appearance regarding her huge robbery. It was not in divorce court. There's a difference. She said she was going in with a positive mindset. Now, listen, I get coming in with that energy of like, I'm walking into court, making my ex eat his heart out. But like, listen, think for a second, because if you're going into divorce court, there's a presumption that finances are a huge part of it, and you don't want to get slammed with being the one who has to pay and give off everything you have because you're the breadwinner. I mean, what are you showing off in that video? The energy I get. But as a lawyer, I'm watching this with my hands over my face like, girl, did your attorneys coach you at all? She basically just produced a time-stamped video the morning of her divorce proceeding in which she demonstrated on camera her access to a Birkin bag, which, guys, how much does that cost? $40K? Designer shoes, those are probably like $10K. I don't really know what they cost, guys. Let me know. A significant diamond stack. They might not be real, but she's presenting them as real. So for all intents and purposes, as far as we know, they're all real. And all that evidence of her financial position, her assets, her lifestyle, she's time-stamping it for the divorce proceedings. Divorce court is not about who did what to whom only. It's about money. It's about assets. It's about what lifestyle was established during the marriage, what each party is entitled to going forward, spousal support calculations, property division, financial disclosure. All of it turns on what each party actually has and what standard of living existed. So like walking into courtroom dripping with a Birkin, diamonds, and after posting a video of yourself getting ready with all of that, You just handed opposing counsel a gift that they didn't even have to ask. And if her lawyer was one of the 17 million viewers watching that video, they were probably feeling things that I deeply understand on a professional level. Because the opposing attorney does not even have to do the investigative work in this case. The evidence has already been publicly posted for them and timestamped. Discovery does not get easier than that. Guys, let this be a warning. Do not post your net worth the morning of your court date. The positive mindset, valid. The serving energy, valid. Maybe save the Birkin reveal for the day after judgment, or maybe just see what your attorney advises. You are paying them a substantial amount. And speaking of attorneys making a substantial amount, reports are now putting the combined legal fees for both sides of the Blake Lively and Justin Baldoni case somewhere in the range of $60 million. So the crazy thing is that the attorneys are the ones who walked away with something in that case. It's crazy because it's like, who won? Which side won? The attorneys won on both sides. And it just makes you think about all the things that happened and like, who was pushing everything along. I'll just let that sit there though. And another interesting settlement happened just on the eve of trial, as we say, which means anytime a settlement occurs in the days and hours leading up to a trial. Erica Jane settled her $25 million bankruptcy lawsuit with the trustee handling the bankruptcy of her estranged husband, Tom Girardi's former law firm, Girardi Keese. This was just days before the case was set to go to trial. Settlement amount is undisclosed. That's why they settle. One of the reasons it keeps everything in the dark. Case was dismissed without prejudice. For those who need a background, Erica Jane's ex, Girardi, was sentenced to 7 years and 3 months in prison last year for fraud. The fact that this settled days before trial rather than going the distance does tell you something. Trials are expensive, unpredictable, and public. Whatever was in the discovery files that was about to be introduced as evidence, both sides apparently decided they didn't want a jury seeing it. And this is a settlement decision, not an innocence decision, and we don't know the terms, but we do know that it's over. Alrighty, folks, that's it. That's your episode. I hope that it was informative and that you were able to learn something fun to be so interesting at your next dinner party or networking event where you can just talk about Real Housewives, lawsuits, Erica Jane's settlement, Caraway's lawsuit, Chud the Builder. Like, who is this guy? You're just going to sound so young, so smart, so cool. And if anyone asks you how you got that cool, you're going to be like, guys, you got to listen to Exhibit A-List. It's the only way. And then you're probably going to go and leave a review. Even if you did so at the beginning of this podcast, why not leave another? Don't forget to subscribe wherever you listen. And as I always say, screenshot yourself listening to this episode, post it on your Instagram story, tag me, and I will repost. Let's go, Knicks. Get into the finals. Court is dismissed. I'll see you next Monday. Stay curious, my friends. Enjoy the long weekend.